And so this was challenged. Some of these faith-based initiative programs were challenged by a group, among others. It was challenged, I think, at one point by the ACLU. But in this case, it was being challenged by an organization called the Freedom from Religion Foundation. And they claimed that this was preferring religion. This violates the Establishment Clause of the Constitution, which prohibits the government of the United States from establishing religion. In this case, they're alleging that they're preferring religious groups over other groups by giving them funding. And the Supreme Court said that you have no standing to bring this case, even though respondents, who are the Freedom from Religion Foundation, alleged that the officials organized conferences at which religious community groups were promoted over secular ones. And the court held that respondents lacked standing under Article 3 of the Constitution. The challenged expenditures, in other words, the money that was being spent by these faith-based organizations, were not expressly authorized or mandated by any specific congressional enactment, so there really was no logical nexus between the fact that they had said, well, we're taxpayers and so we don't want our money going, we pay taxes and Congress is spending our money on religious organizations, on religious goals. And so they said, well, there's no specific taxpayer dollar that was earmarked by Congress for this purpose. It was just spent by the president as part of a broader power to spend for these programs. And that was, again, it's a little more complicated because there was something called taxpayer standing which they were trying to use. But in essence, what the court was saying is that you are not being hurt by this. The fact that the government is spending money on faith-based initiatives does not hurt you. It may make you feel bad, you may not like the idea, but that is not a legally cognizable injury. So therefore you have no standing to sue, you have no standing to bring this lawsuit. So you can see from Allen and from Hind and from this doctrine in general why these pastors have to go ahead and be investigated by the IRS before they can bring the action. These pastors are saying over here, well, the IRS rule says that we're not allowed to endorse candidates, we're not allowed to espouse certain political viewpoints and keep our tax-exempt status. We want to challenge that. Well, how do you challenge that? If you just bring a case and say, well, we want the IRS rule struck down, the court is going to say, what are you doing here? You have no standing. You have not suffered a legally cognizable injury. So therefore, what they need to do is they need to bring what's called a test case. They need to violate the rule, have the IRS enforce the rule against them, probably by revoking one of these churches' tax-exempt status, and then, and only then, they will have suffered a legally cognizable injury, because now they will have had their tax-exempt status revoked, and then they can go ahead and bring this case. Okay, so the next question is there any precedent to determine what will happen when this case actually goes to court? Now, this will probably work. At some point, whether it be now or in a month from now or in 6 months from now, the IRS will try to revoke somebody's status for taking a political position, especially if pastors are going to go to the pulpit on Sunday and start blasting certain presidential candidates. I figure they'll probably blast one more than the other, but either way, somebody will eventually be subject to the IRS, coming down and trying to revoke their tax-exempt status. So let's take a look at some of the background rules and see if there are cases that have dealt with this at any point. Well, let's look first at the statute itself. Whenever you're talking about a statute being challenged, that's always the first place to look. This is Section 501 of the Internal Revenue Code, which deals with tax-exempt organizations. Those of you who have dealt with charities before, you may have heard the term 501c3. The reason why you've heard that term is because 501c3 is the section of the code that says that religious groups are exempt. As you can see, Section 501, exempt on tax on certain corporations and certain trusts, and this is Section C3. I skipped the rest because it's not really relevant. Any community trust, fund, or foundation, or operated exclusively for religious, and then charitable, scientific, testing. Religious is just one out of a whole bunch of different possible purposes that an organization could be exempt based on, but religious is the one that we're referring to over here. But look at some of the caveats. There are a whole bunch of other caveats. It says over here, no substantial part of the activities can carry on propaganda, whatever that means, or to influence legislation, and this is the important one, this is the one we're looking at now, that's why I put it in red and in italics, which does not participate in or intervene in, including the publishing and distributing of statements, any political campaign on behalf or opposition to any candidate for public office. So clearly there's no question, and everybody agrees, that saying that you must vote for John McCain, or you must vote for Barack Obama, or you're not allowed to vote for John McCain, or you're not allowed to vote for Barack Obama, would violate, if you are a church, You're a pastor, on Sunday services, and you get up there and you start saying that you're not allowed to, the Bible says you're not allowed to vote for Barack Obama, well then clearly that violates this rule, and your church would be subject to tax-exempt, to revocation of the tax-exempt status. The question is this constitutional? Should this be allowed? Well, we all know, or many of us know, the first clause in the entire First Amendment to the U.S. Constitution says Congress shall make no law regarding the establishment of religion, nor prohibiting the free exercise thereof. Congress is not allowed to establish and prefer one religion over another. That's something that we saw before in the case a few minutes ago that we looked at, in the Hine case. But in addition, Congress is not allowed to prohibit people from respecting and practicing their own religion. Well, does this violate that? Does the fact that the IRS is saying, when you practice your religion, if you want tax-exempt status, you are not allowed to endorse or endorse the opponent of a particular political candidate, does that violate this particular, does that violate the Constitution itself? That's really will be the question in this case. To start with, the Supreme Court has ruled in previous cases, and there's in a whole series of cases, that if you have a rule of neutral applicability, if you have a rule that applies equally to everybody, there doesn't inherently have to be an exception for a religious practice. In other words, if you have a general rule, let's say, for example, speeding on the highway is illegal, and some religion says, well, our religion says that you have to speed, the government does not have to change that rule. That's not considered an unconstitutional violation of religion. One example was a very famous case called Employment Division of Oregon versus Smith. What happened in that case is certain religions that were espoused by certain Indian tribes required the smoking, or was part of the religious ceremony of smoking of peyote, which was, I guess, a form of marijuana. And they were fired for that because the Oregon state government had a rule that said that if you smoked marijuana, you were going to be fired from your job. They worked for the state, and they applied for unemployment. And they were denied because they said that you were fired for misconduct. And they said, well, we were just fired for practicing our religion. That's unconstitutional. You can't deny us unemployment. Well, the Supreme Court said that's okay. You can fire those people for smoking peyote, even though it was their religion. And the reason is because the court said, they have on the bottom over here in orange in italics, the free exercise clause was inapplicable, doesn't even apply, because the state law was not aimed at promoting or restricting religious beliefs. It was just aimed at general applicability. It was a general anti-drug, anti-marijuana law. Because the employee's peyote use was prohibited and the prohibition was constitutional, Oregon could deny the unemployment compensation. You don't have to adapt the state law. There have been many other cases. I mean, there are cases where the court said that if it's reasonable to make an adaptation, you should. Like in a famous case, for example, called Wisconsin versus Yoder, the Supreme Court said that for Amish, the Amish school children who usually stop schooling at age 13 or 14 to go work on the land, that the states should make an exception for. Even though there's a general rule in many states that you have to go to school until you're 16, you should make an exception for the Amish because I guess it's something that's reasonable based on their society, and there's really no inherent reason not to make an exception. But in any case, there have been many cases like this. But the general rule is that rules of general applicability do not have to conform to individuals or groups' religious beliefs. It's actually very interesting, and just a little bit of a tangent over here, but about employment division. A couple of years later, Congress did not like this decision of the Supreme Court, where the Supreme Court said that states are allowed to, use these kinds of rules of general applicability even if they infringe on people's religious belief. A couple of years later, Congress passed a rule called the RFRA, the Religious Freedom Restoration Act. Kind of a loaded title over there. In essence, it reversed Smith and said, for this kind of a situation, when you're talking about unemployment benefits, you're not allowed to punish somebody for following their religious beliefs. In many cases later on, many religions used that to their advantage, the Religious Freedom Restoration Act. Interestingly enough, 12 years after Smith, and about 8 or 9 years after the Religious Freedom Restoration Act was passed, the Supreme Court reversed the act itself in a famous case called City of Bourne versus Flores, where the Supreme Court said, actually it was also in the 90s, I'm sorry, it wasn't 12 years later, but in any case, the Supreme Court said that, in essence, to Congress, this is none of your business. the interpreting freedom of religion, interpreting the Constitution's freedom of religion clause is the Supreme Court's job. It's not Congress's job. So basically, you know, butt out. And we'll decide when somebody's freedom of religion is violated. That's not your job. And the Supreme Court struck down the Religious Freedom Restoration Act, saying that it's not Congress's job to tell the states what they're allowed to do regarding people's religious beliefs. That's the U.S. Constitution